Redundancy is one of the 5 fair reasons for dismissing an employee. Redundancy is not unlawful, particularly and of course when handled and done properly. Now, where there are mass redundancies taking place, and it's not, for example, just some kind of individual selection, it's usually difficult to bring a claim or think about having to negotiate whatever the exit package may be. But where indeed it is some kind of individual selection, or it seems to be the case that your employer has just sat you down and said, oh, by the way, we're making you redundant, then it might be the case that there's something that you can do about that. Unfortunately, most of the time, redundancies are a cloak, they are a sham, and employers will often use the term redundancy in order just to get rid of someone, to get rid of you, because of some other subjective reason. Now, if that is the case, or you perceive that to be the case, or it may be the case that the redundancy process has just been a complete mess, and one moment they're saying one thing, the next minute they're saying another, and you are not thinking that things are actually all that they appear to be, again, there may be something that that we can do about that for you. Now, evidence is key. Evidence is key. Whether it's in writing, so letters, emails, or you may have some recordings as well of conversations, whether it's in your stage 1 or 2 meetings or consultations that you've had with your employer, or indeed whether there are witnesses who may be able to help too. But again, in employment law, witnesses can be tricky, because more often than not, the witnesses that you may be looking to rely on work for your employer, and they themselves may not want to be in a predicament themselves. But nonetheless, witnesses are usually helpful to have on board when looking to negotiate an exit, because in many instances where, and if you're in the mindset too, that you may want to leave and you may be being made redundant, you may not have a lot to lose anyway. So you may as well go all out and do your best and try and get the best package possible. Now, some people already have somewhere to go to, so this might be an extra incentive for them to make the most out of their situation. But again, every case is different, and in any event, it's really important that you get legal advice to go through the merit of any potential case that you might have, and indeed the sorts of things that you may be able to do when it comes to negotiating an exit package or negotiating your redundancy. Now, some of the things that we would be able to think about, some of the factors that we would consider when looking at your exit package, are things like your length of service, your seniority, the relationships that you have with various members of staff, all the way from the CEO or the directors, partners, or line managers, etc. It may be the case that there are grievances in the wings or disciplinaries potentially as well, or other factors that may need to be considered. But again, in any event, before you make a move, and preferably sooner rather than later, it's important for you to get that legal advice so we can talk about tactics, strategies, and the best way for you to leave with exactly what you want. So you're welcome to get in touch. Details are appearing on the screen, and I will be more than happy to help you. Thank you.